right, welcome back. So we're still under the standard of review. So you'll recall we looked at the very important stuff first, and that is the presumption of reasonableness review, which always applies, regardless of the type of issue being reviewed. Then we said there's 5 reasons for which you can rebut the presumption of reasonableness review, and we enumerated them specifically. Now we're beyond that. We're in the substance of reasonableness review. How do you conduct reasonableness review once it applies? So, within that, right, the actual review process, we said there's very limited directions being given by the Supreme Court in Vavilov and other precedents as to how you review a decision, what it means for it to be reasonable, how you assess that. One of the specific things that's given is that it has to be, right, justifiable, and in fact justified for the reasons we mentioned, based on the factual and legal constraints bearing upon the decision makers. These are the magic words, they're important, right? So that means what it says, it's obvious, right? The context, so the statute, the power that the decision maker has. Factual constraint means the record, the evidence, the people before it, right? The ingredients, the law and the facts, right? The people, the documents, and the law you combine to come to a decision. These are the factual constraints, and they have to justify the eventual decision that's made. That is declinated more specifically. I won't write it down on the board, but pages 464 and following should be like the Bible. Extremely important stuff. And it's how you conduct review. There's 2 categories of errors, doesn't really matter, right? First, a failure of rationality, and I'm at 464 and following. So, and again, I'll read almost verbatim because it's extremely important. So, first is a rationality problem, a factual and legal constraints problem within the decision itself. So, it's not coherent, right? You don't get from A to Z. You don't get from the ingredients to the result. You don't get from the justification to the outcome that you're trying to justify. So, first, within the decision, right? 1, sub error 1 out of 4. 464 again. Unreasonable if the reasons read holistically fail to reveal a rational chain of analysis. These are some magic words again, very much used in later case law. Or if they reveal the decision is based on an irrational chain of analysis. So you read the reasons, right? The judgment or whatever it is, and you can't get from the ingredients to the outcome. 2, a decision will be unreasonable where the conclusion reached cannot follow from the analysis undertaken. Similar to number 1. 3, a decision will be unreasonable if the reasons read in conjunction with the record do not make it possible to understand the decision maker's reasoning on a critical point. It's something we mentioned earlier. We said you don't have a right to reasons, and oftentimes there will be no reasons at all. But you have a right to know why the decision was made. So if there's no reasons, you can piece it out from the record, from the stuff that was before the decision maker, to try to understand what went on. If you cannot do that, it will fail, essentially on procedural fairness grounds. And that's what it says. If with the record you can't understand how a key issue was decided, it fails. 4, the internal rationality of the decision may be called into question if the reason exhibits clear logical fallacies such as circular reasoning, false dilemmas, unfounded generalization, or an absurd premise. So essentially, right, same thing. You can't get from A to Z. The second category of errors, so that was internal to the decision, to the reasons, to the reasoning, to the justification for the decision. The second category is when you have the factual and legal constraints. So when you go beyond the decision and look at the broader context of the record and the statute. So, what are the factual and legal constraints? That's the hard question, right? And it's generally the context, and it goes pretty far. First, 466. Again, it's like a Bible, right? 1, the governing statutory scheme, the statute, because again, gives it its power, bounds the power, all that. The majority's discussion indicates that it is likely the most salient aspect of the legal context, of course. So, what can you not respect? The rationale and purview of the statutory scheme. So, what the statute says and its underlying purpose, which we said bounds everything. It bounds jurisdiction, bounds procedural fairness, right? All the issues we saw during the term. B, failure to comport with any more specific constraints. So specific, again, underlying statutory scheme, the purpose, the intent, not written, but bounds as much. The specific provisions. C, fettering a wide grant of discretion. It's something we saw a couple weeks back, right? We said discretion is generally for a decision to be made more compliant with justice, and it allows for flexibility. We said you can bound discretion, you can limit that by, say, providing for guidelines or for mandatory guidelines that a decision maker will apply in deciding. But if you do that too much, it fails because you essentially eliminate discretion and you attack the underlying principle of discretion, which is that flexibility which you have to have. Finally, right, D, arrogating powers, which the legislator did not intend to arrogate. So, permutation of the previous one. 2, other statute or common law. So you go beyond the home statute, the enabling statute, a decision maker or rule maker. Other statutes and common law will impose, of course, right, statutory or legal constraints bearing upon the decision maker for the general meaning of the phrase in value of. So, A, tribunal cannot interpret its statute in a way that's inconsistent with broader legal principles from other statutes or the common law. Makes sense. B, where a governing statute specifically specifies a standard that's well known in the law and jurisprudence, a reasonable decision will generally be consistent with it. So, careful there. There's no case law. So, the decision maker does not produce case law. Their decision don't have to be followed in future and similar cases. That's the nature of the administrative system. As a corollary of that, they don't have to follow prior decisions. We said, though, if they're decisions from courts, oftentimes they will have to be followed. That's the oftentimes there. So, if they choose not to follow a consistent flow of case law from a court or from prior decision makers, they might be able to do that, but they will require a proportionate justification. So it doesn't mean they can just do it however they want because they don't have case law or don't have to follow or create case law. They might have to provide a proportionate justification to get away from, right, prior cases having been decided. Okay, C, same thing. D, decision may be unreasonable or rigidly applies inequitable or common law principles without adapting it to the relevant administrative context. E, international law, don't worry about that. 3, principles of statutory interpretation. So, the decision maker has to interpret the law in accordance with regular principles of statutory interpretation. Won't read them in detail, not all that important for our purposes, but essentially what we discussed throughout the term. Okay, 4. I'm at 468 now. The evidence before the decision maker. So, the decision has to be justified with the evidence. You'll see a consistent pattern there. They don't have to do everything. And don't have to do everything perfectly. So, They don't have to deal with every single piece of evidence. So you can't go on judicial review when there's 200 exhibits, documents in the record. You can't go in and say, right, they did not discuss exhibit number 68, therefore they misapprehended the record. It doesn't work that way. If it's an important piece of evidence and they didn't deal with it though, then it's a reviewable decision. So, fundamental principle there, which we'll see applies for other things. They don't have to discuss everything, but they have to discuss the important stuff and do it adequately. Right? Adequately meaning justification, transparency, intelligibility. It has to add up, right? With the piece of evidence, the decision they eventually made, and the reasoning in between. 5, submission of the parties. Same thing. You have to deal with all important issues, not all issues, all important issues, and you have to do that adequately. That's essentially what you have under number 5 there, 468. 6, the tribunal's past practices and decisions. So, what I said earlier, no need to follow the case law, but might need a compelling justification not to follow it. 7, the impact of the decision on the person's life. We said that tons of times, mainly under procedural fairness, but also I think jurisdiction, right? Essentially, you have to have that be proportionate with the nature of the decision being made. And all of these, technically, are things that can individually invalidate a decision, make it unreasonable, because they are each factual and legal constraints bearing upon a decision maker, and that is what you review when you conduct the standard of review analysis. And then you have a very interesting history of the standard of review, which is not all that helpful for our purposes. And I think that we will pause there for this week.